So, should you settle on your primary treating physician, the PTP, or should you get a QME, qualified medical exam, to get a second opinion? I can't say what you should do in your case. I will say that in general and in my experience, I rarely settle on a PTP report, and kind of let me explain why. So in my experience, probably in the last 2 years since I came back from the bench, I can think of one case that I settled based on a PTP report. Every single other case that I have settled for my clients has been off of either a QME or, in a represented case, an AME. We have an option of going to an agreed medical examiner. An injured worker without an attorney doesn't have that option. You have to go to a QME. So for you, an injured worker, you can settle on the PTP, or you can request that panel of qualified medical examiners. You get a list of 3 doctors from the state. You get to choose, if you go fast, which doctor it is. You schedule an exam. You get another report. So 9 times out of 10, no, more than that, 99 times out of 100, in my experience, QMEs generally write better reports for settlement than PTPs do. It's because the primary treating physician in workers' comp, especially in the Central Valley area where I primarily practice, the primary treating physicians are focused on treatment. So they are focused on, how can I minimize the pain? What medication can I prescribe? What specialist can I send you to? How can I get you back to work? It's the focus of a treating physician is treatment. They're not focused on the medical legal aspects. So when you settle a workers' comp case, it's going to be based on a medical legal report. Some primary treating physicians can do that, but again, that's not their focus. Their focus is treatment. Once you get to a permanent and stationary status, that primary treating physician may write a report, but based on what I've seen, they don't have the experience with the AMA guides. They're not up to date on case law. They're just not as good at going through the AMA guides to find the impairment, using Almaraz-Guzman to find the most accurate representation of the impairment, really discussing apportionment in alignment with current case law, and addressing permanent work restrictions. It's not the wheelhouse of the primary treating physician. For the QME, it is. So for QMEs, they may do some treatment. They may do some other consulting or writing reports, giving lectures. But for a QME, they're licensed by the state of California to write med legal reports. This is oftentimes their real focus. They're better at writing this because this is what they're trained to do. This is what they are experienced in. So a QME has to write a report that addresses whole person impairment. They have to address apportionment. They have to address causation, if that hasn't been addressed yet. They need to address permanent work restrictions and anticipated future medical care. Based on what I've seen, most of the time, QMEs are better at going through the AMA guides and saying, well, for example, a DRE2 may be the strict application of the AMA guides for your low back injury. For a lumbar injury, there's a specific injury, there's radiculopathy, it's non-verifiable, a DRE2. A primary treating physician may just place you in DRE2 and give you 5 to 8% whole person impairment, done with it. A QME can also say, is that the most accurate representation or the most correct picture of the impairment? And if it's not, they can go through the AMA guides and maybe draw a parallel to another section, maybe draw another parallel to the lumbar spine section, maybe to a completely different area of the AMA guide, such as a hernia, Lord knows. QMEs can get more creative. So in my experience, you can settle based on the primary treating physician report, but almost always the injured worker is better off seeing a qualified medical examiner. I know that when I was on the bench, settlements would come in. They were based on the primary treating physician, but because the injured worker would just say, it's easier, it's quicker. I have the treating physician report. They already offered settlement. Be done with it. So it's true, it's quicker. Is it going to take more time to go to a QME? You bet. It's going to add months and months to the case to go to a QME. But when I was on the bench and looking at injured workers' cases, I would often tell them, it would likely be in your best interest to go to that QME if the primary treating physician report was substantial evidence and I felt was accurate enough, then I could approve the settlement, or I could disapprove it and instruct the injured worker to go to a QME or order the parties to do that. Because most of the time, it's in the injured worker's best interest to go to a QME. This is especially true if you've been treating for the last year or two with the doctor that the employer first sent you to. That doctor is generally more friendly, more favorable to the insurance company and to the employer than they are to the injured worker's side. That QME is completely independent. They don't care about the insurance company. They don't care about you. They're completely neutral in the middle. They're not a one-sided doctor. So in my experience, can you settle based on the PTP? Sure. Are there times when it might work out for the best? Sure, you might get a very good report out of a PTP. But most of the time, no. Most of the time, I believe the injured worker is better off going to a QME, get a completely independent review of the medical reports and the injured worker's condition, and a med-legal exam that's written by someone who's a state-licensed QME. If you found this video helpful, hit the like button down below and be sure to subscribe so you don't miss future videos.